It is. Good afternoon. Welcome again, everyone. Today's live video webinar with Felicity and guest, child maintenance difficulties in South Africa. Felicity, how are you doing?
I'm good, thank you. Improvising, but absolutely great, thanks.
Yes, it's super hot. It's super hot inside. You're lucky to be outside. I am, and I cannot put the aircon too loud or too hard on because you wouldn't be able to hear me. So that's one of the things. So Felicity, what happened in the last week? What's happening?
Um, yeah, so I would just like to just share with you and particularly the viewers is that from a few of my coaching sessions, there has the women, my coaching sessions have been with women the last week. They've all had great success. One An important aspect of making an application, whether it's a first-time application or an arrears, is one's emotional state. And I'm really, really aware of that. And for legal practitioners, they don't really understand that because that's their job. They do this all the time. They don't have an emotional attachment to it. It's another kind. And I don't mean that derogatively, but it's a fact. But for each individual person, it's personal. And the courts represent a place of authority, and it is intimidating for most people, particularly if it's your first time or if you've had a previous experience and a bad experience. So a lot of aspect of my coaching is actually dealing with the emotional aspect of it, making them aware of what to expect and coping techniques, relaxing, calming techniques, and go through all that well. And it really echo. So it's then to just explain to them what to expect, because what we expect and what actually happens are two different things. So I go through what the real expectation is, and that is to not expect really to be helped from a understand compassionate point of view, So just and then in that is the confidence also comes in knowing the act and knowing how to present your case, and how to defend your evidence or your requests from an unemotional point of view, because we know that emotions don't really have a place in law. It's deal with the facts, but the emotion aspect is a big side. And then I just prepare them on how to just in a very neutral way to bring people back to the act if they are digressing from the act or saying things that are not really within the framework of the Maintenance Act, which we know happens a lot. But to do it in a way that is not arrogant or anything, because that also is a form of alienation. Anyway, so I go through all of those aspects with clients, and that each of them actually had like great success, different cases. The one mother got more than what she was prepared to, the absolute minimum that she was prepared to accept, and that was in spite of him arriving at court with 3 attorneys or 3 lawyers, with 3 legal representatives, and she was unrepresented. And that she managed to hold her own. She did like ring me in the morning and go, I can't breathe, and I just like took her through breathing exercises, and I go, important to stay centered and to just focus on the facts and try not to be roped to an emotional response. And then later in the day, she messaged me to say that she got more than what she was prepared to settle on, and that she was calm, and and thank you for the coaching session. So so and that's all before we get into the actual form, because once the forms themselves are so confusing, Mohammed. I mean, they appear to be simple, but they're not. It's not to the ordinary person. There's not many people who sit and fill in a JD 101 and go, oh, that's easy, I can answer that. I mean, most of them come back to me and go, can you check it? And invariably that misinterpret it.
I think the problem also is, Felicity, that those forms are all created, I think, close to the time the Act was promulgated in 1998, if I'm correct. So it needs to be modernized. It's 23 years old. Um, but Felicity, on that specific note, I think the individuals themselves, despite the act, the form being complicated, etc., they still need to look beyond that and make sure that every single thing they require to prove the maintenance amounts must still be presented as best as they can. But a funny comment early on, he didn't. Yes, he did appear in court with his three lawyers, but usually it's the attorney, the candidate attorney, and the advocate. So that those were the three lawyers that appeared for one of your clients early on. Felicity, I will go through that forms quickly. You have the form in front of you. I'll screen it on the screen. And whatever you speak about, I can comment afterwards. Once we're ready, the viewers can see it as well. Let's start from the first page. I think, is it? Yes.
Sure.
It
The
starts.
first page is pretty simple and clear. It just asks for the relevant information of the applicant, of the defendant, and the details of the child. Sorry, I'm just turning the page. And all of that information is relevant because that is your reference number. Our ID numbers become our reference numbers. So if we lose our court case, our case number, they can still access it via our ID numbers. So when one approaches the court, it's important to try and have all that information because although it's allowed there's provision in the Act for the courts to, or the owners, I don't know if that's the correct word, but if you don't have the details, that they have the mechanisms to actually find those details. But I mean, if you don't even have an ID number, that's really problematic. A lot of people only have a telephone number, and we know that those are disposable. You can get rid of that and get a new number, and then what? So it's really important to have all the identity documents and the place of work and the residence. And to try and do it yourself, because then at least you've got it. Because if you make the application and you don't have that information and expecting the courts to find it, you have no control over when it's going to happen. So to expedite your case, it really is in your own best interest to go completely prepared and to have all that information.
Yes, Felicity, especially with the address of the party. Yes, there is maintenance investigators. We know that, but they are unfortunately busy, and for somebody to find someone, it can be very hard. Therefore, before you approach a maintenance court, first make a concerted effort to at least obtain the person's work address, home address, cell phone number, which is very useful because once someone gets a phone call and say I'm the maintenance officer, etc., they usually do comply. And identity number, if you can. It will assist the process greatly. Obviously, if you the reason why I'm also saying this, Felicity, is once a user court makes a maintenance order against a name, but we do not know who this person is. So the maintenance order is basically useless. Therefore, we need to serve it upon him and get money from this person.
Yeah. Yeah, so that's this page, and the second page is also just elaborating on the relationship to the child, and then space for the children's details, their names, and the amount and the ages. And it also just asks for some information of, when you expect payments. Although we know it's just a conversational thing or a starting point, it's not necessarily happens on the final order. It's just collecting information. And then we go on to the real need, or the main part of the application, and that is the evidence. And it starts off with, so just for people to understand, so when you make the first application, you are providing this information. And when you hand your form in, this is your information. They then request the defendant to to provide exactly the same information so that on your next appearance that they have both sets and that they can make interrogate that and make informed decisions. So and it depends on service and it depends on availability of a court date. So unfortunately there's no norm of how long this process takes. So the first part is assets and income. So that because that's important, because Maintenance Act says that the amount returned is proportionate to each person's income, which is very seldom equal. So that's why that information is important. I'll come back to that. And then it moves down into a detail of the expenditure. So the first one is lodging on rent board. And that is quite confusing because it doesn't, it says self-insurance, but it doesn't explain how you get to those figures. And there isn't a proper model to work from. I mean, there's almost like an assumed norm or that people work from, and that is, if the example is a mother and a child, then it's 2/3, 1/3. And that's pretty simple, but people don't know that if it's the first time application, you haven't got information from anyone else. But what happens then if it's a primary caregiver and 2 children? Does it become a half and a quarter and a quarter?
Yeah, no,
What happens if it's a mother and 3 children? Or 4 children? What is the method that we should actually use on this?
No, Felicity, if the form is obviously not very modern and useful, but if it's 4 children, that amount must be divided into 4. What I would advise people to do is when you dealing with a maintenance application form and there's more than 1 child, to attach your own spreadsheet explaining. So you take the spreadsheet. I think on our website, our lawyer website, also you can download, type in our lawyer maintenance application form, child maintenance calculator, and you will get a spreadsheet, and you can, there are columns for child 1, child 2, child 3. The purpose behind this form is basically to get the people to start the process. But you are 100% right. When you have 2 children or 3 children, it's confusing. I mean, what do? You stipulate in the form that all my 3 children cost 1,000 per month for one item, but at the maintenance inquiry, you still need to unpack it. You have to say, no, for this child, her school fees is, for simple figures here, 100 Rand. The other one is 200 Rand, and the other one is 300 Rand. So, although you put in the amount of 600 Rand, the maintenance court will not be the wiser. Therefore, I advise everyone, please have your own spreadsheet, and whereby you can unpack your own amounts. At the same time, many items in this form is not relevant, or it lacks certain relevant information. Therefore, in your own spreadsheet, you can outline all the additional things which is not stipulated in this current form.
Yeah, okay. That's really, really helpful. And then, so just I suppose once they go digital, that these things can be completed online, it will probably be a lot easier to fill in. Then the groceries, your suggestion would also be very relevant. And also, if people don't collect slips as proof of payment. So I normally say, well, from the time you make your application, start collecting slips, because invariably it's a 3-month wait until you appear in court. So by the time you get to court, you can adjust those figures, and you've got the necessary slips to be able to pick up your amounts that you've written down. And then that also, so it goes down, because what people don't understand, and it's very confusing, because the Maintenance Act essentially, and the Bill of Rights and all of that, speaks to 5 main elements, and that is shelter, food, education, healthcare, and clothing. And if you look at the form, there's more than that. So obviously, if the child lives in a household, it's got shelter, but part of that shelter is water, and there's electricity, and there's rates and taxes that need to be paid. If you live in a complex, there's the levy for communal garden service, whatever it is. And those all become shared expenses because the children benefit from that. So, yeah, people just don't understand. When they get to court, they don't even take those things into consideration very often. And they just stick to those 5 basics that are mentioned because that is the provision. That is the absolute least. And I think that is the point of it, isn't it? That those 5 elements are the absolute minimal. It doesn't exclude the other stuff, but those are the big minimal requirements. Is that correct?
It's 100% correct. Felicity, I would say the form is outdated. We confirm that. It needs to be modernized. The Maintenance Act came into operation in 1998, if I'm correct. Many years ago, things have changed. Many of the kids that were born that time and the Maintenance Act was applied to them are now adults, parents themselves. So there needs to be a bit of a revolutionized issue. But the law applicable in the maintenance court is still the same. We still need to know how much the child costs, how much the parents are earning, and how much the expenditure are, etc. So knowing that the forms are a bit defective, you need to make sure that everything is done. And it's vitally important. And Felicity, I always advise clients when you draft these forms or when we draft it for the clients, can we substantiate it? The worst you'd want is to stipulate an amount in the maintenance form for groceries, for argument's sake. Let's say you say it's 1,000 rand per month, but you only earn 1,000 rand per month. I'm using round figures here, and there's 4 kids. Clearly, you are not incurring those type of expenditure. Clearly, the kids are not costing that. Whereby you'll have a maintenance inquiry, a formal maintenance inquiry, whereby you need to show the court that you require so much money, but every item is, inflated. The whole inquiry takes place based upon an issue concerning cross-examination, whereby your credibility is attacked all the time. Therefore, apply your mind properly, because there's no legal obligation upon the other parent to maintain the adult parent, the complainant. That's clear. The obligation is for the minor kids. And therefore, it's very important to make sure that you work out the calculations properly. The court can be convinced this is a fair amount, and everyone will be happy from there.
No, absolutely. And I mean, I normally advise people, where possible, to payments from your debit card, because then your statement is a very easy place to reference, because you have to supply a bank statement anyway, but at least all your receipts and whatever are collated in one place. And then, if they got like, you spent like 1,000 rand 2 days in a row on food, then that's where your slips come in. If you are asked to justify, and normally it's only when they, like you mentioned, that the amounts seem inflated or unreasonable, that you would really be required to justify them. I mean, they don't normally nitpick if it doesn't seem unreasonable. If it seems reasonable, they very seldom nitpick. If you give them reason on one point, then they're going to interrogate every single point. So yes, it's very important to stick to the real facts, because that is what is going to be used to determine the amount at the end of the day. And as you say, it's your credibility. Because when you speak and you say, well, every single day I'm having to do this for extramurals, then they might believe you, because you're able to justify all of the other expenses. So so let's go back to the form. So the first part covers all the household expenditure, and it has a whole range of things. And then clothing. And then again, like often with the clothing, so it seems common practice and Act allows for periodic payments. And clothing seems to be one of those items that is often paid twice a year, or twice a year in July and in December. And so I see it on the form, because it's not very clear here, that they put the yearly amount for certain expenses, and clothing is one of those. So, on face value, you can go, but you've got like 2,000 rand here for clothing. Is that every month? Because it doesn't have a column per month or per annum. So I suggest that amount goes into the total and then divided by 2 amounts if you're asking for July and December. And in that column, actually state in there that it's for July and December clothing, so that they can see clearly.
No, Felicity, generally when these forms get filled out, and they are yearly items. For example, let's say a yearly school fee amount of a TV license amount that's yearly, or car license that's yearly. All that you do is you divide it by 12 and you put that small amount in. This form is created on a monthly basis. So if the kids' school fees is, for example, 1,000, sorry, kids' school clothing or normal clothing comes to 1,000 per year, or maybe easier for me to say 1,200 per year, you just stipulate an amount of 100 rand in there, and because we're trying to calculate what amount the father should pay on a monthly basis. So if the kids cost on a monthly basis so much money, although on a yearly basis it's quite different. Um, that's my view on that.
Yeah, well, that's exactly what I tell them. I tell them to start do a rough copy first, so that you can hash through and get it correct, and then on your official form, do the total and then work backwards, because then it's easier to understand than try to work it the other way around. And then there's transport, which I'm not going to go through in detail, but it's the same principle that applies there for installment insurance, maintenance, fuel, license, parking, etc. Because if you are having to transport your kid to school every day and you're having to pay parking, well then obviously parking is relevant. Or if you take it out to extramural activities and it costs you 50 rand every time you go, then it's relevant because it's part of those costs. And then the next item on the next page is educational expenditure. I'm not going to go through because we've discussed the methodology of all of that. And then medical expenses. So I had a situation the other day where there isn't actually a column for medical aid on the form. So, it talks about dentists, medication, hospital, other medical expenditure. And that is it's not everybody has their own medical aid. Some children are on their father's medical aid, and some children are split. So it can be quite complicated on some applications. So, and these generally, if you're on medical aid, out of savings expenses that you're paying for cash that are not covered, and then over-the-counter medications like Panadol and your passes and whatever else that you're buying over-the-counter. And then obviously if you're not on a medical aid, or even if you access the government department, a government hospital, you still have to pay an amount, even if it is minimal. So that needs to be broken down. And again, like you said earlier, that if it is a lot more complicated, then have an extra so that you can include it with a more detailed breakdown on the expenses.
Felicity, on that point which you mentioned, sorry, I must mention this before we go on, especially that you mentioned about the next year. There's a reality and there's a perfect scenario. The perfect scenario would be that the mother is incurring all these type of expenditure per month, but she's borrowing the money from her mother, and these are actually the child expenditure. And is the reality. The reality is many of these items on this application form, the mother is not incurring. That's why she's going to the maintenance court in the first place to obtain that. The maintenance application form, which the government is published and made available, does not deal with that scenario. Therefore, in your spreadsheet, deal with two scenarios. Or maybe place a column in over there and saying these are the actual things I am currently paying for the minor child, groceries and clothing, which is the general thing. And these are the things which a minor child requires, which I'm not currently paying for. And so we have two amounts currently and what we require. So obviously the father's or the mother's maintenance obligations, whoever will have to be paying maintenance, will be based upon the actual thing what the child requires. Because if the child requires clothing, but you have not bought a single item of winter clothing for the last year for the minor child, the father can't come or the other party can't come and say, no, but this is not an expense. It's not an expense because you are not contributing and I do not have the money for that. So I have two columns where that is concerned. That's just my quick 2 cents on that.
Thank you for raising that, because I had a situation with the other day who said that she lost her job, but the mother had she moved in with her mother, and the mother was picking up these expenses. and that's the rent and the clothing and the medical and most of the child's expenses. And she said that the agreement between her and her mum is that as soon as she's earning an income, that she actually has to pay some of that back, because in these scenarios, the grandparent is taking out of their savings to provide for the they often don't have an income, so they're taking out of their savings, and not many are in the position where it doesn't matter. I mean, that income does matter. So they have an informal agreement whereby as soon as there is income, whether it's getting maintenance now or you have a job now, that you have to start repaying these. I've suggested to my clients that they get that agreement in writing so that they can submit that to court as well, because then they can submit like the bank statements and all of that from that particular parent.
That's extremely useful. And for the sole reason, if the mother has been incurring those upper expenditures, on the maintenance form, obviously there's a part of the dealing with debt and so on. We can stipulate I have so much debt, but then the calculations adding on to that must make a logical sense. In the sense of, if the father never paid maintenance for the last 10 months and your shortfall was 10,000 per month, your debt technically can only be 10,000 per month. Your debt can't be 30, 40, 50,000 per month. I'm just emphasizing the aspect you need to speak. You need to think as an accountant. The books must balance. If it doesn't balance, any half-trained lawyer on child maintenance law will definitely pick it up. But let's see. We have an online live question which we'll deal with after we're done with the form.
Okay. So then, for medical expenses, then we have insurance, pocket money allowances, holiday entertainment, recreation, maintenance of the household. I mean, kettles break, toasters break, brooms break, all of those kind of things. And then it goes like the rest of the stuff: personal loans, security, membership fees. It could be a gym. It could be like a national parks green card or something, recreational thing. Religious contributions, gifts. Children go to a lot of birthday parties. TV license, and then reading material, lease, credit agreements, and pets. So that is then the last one is for unspecified items. But, also these things that I often have that I can recall being in the Maintenance Act, or the Children's Act, or maybe even the Divorce Act, where it says that looking at maintenance, it needs to be taken into consideration that children are workable, maintained in a standard that they're accustomed to.
No, for Felicity, I don't think the Maintenance Act specifically says
Mohammed?
that. That will obviously be case law that mentions that the general principles regarding how a minor child should be maintained. So in applying that principle, it's a well-known principle that kids, in applying the best interest of the child principle, if a child went, for argument's sake, to a very good private school, and the parties separated, and now you're saying, no, I just want to pay for a normal school that is not as good as a school the child is used to, despite me being able to afford it. That cannot work. The child is entitled to have the school he is used to. On that basis, but at the same time, if the other parent can no longer afford to put the child in that school, generally happens is once people separate, there's now two bonds, two lease agreements, there's two homes, so the income generally does become a bit less. So naturally, if you work out the calculations, people might not be able to afford what they could usually have afforded while they were living together as a couple. But we all know many maintenance disputes are based upon the fact that people were not living together and they started the relationship, not living together.
And then the other thing that I want to discuss, because it's very relevant to this, is, and it seldom happens, is that in the Maintenance Act it clearly states that the mother can claim expenses from pregnancy, and this is obviously more relevant for people who are not living together or break up in pregnancy, that the mother can claim for costs incurred during the pregnancy and from day one of the child's birth. That is clear in the Maintenance Act. But I'm not aware of a single instance where that has actually been applied.
Yeah, I was lucky enough to argue the point in Weinberg Court many years ago, maybe like 12 years ago, on the issue concerning maintenance since the parties separated, backdated the maintenance. So let's say the child was 3 years old, they separated, child is now 10 years old, and the maintenance magistrate told me in court, and this is when the Maintenance Act was maybe 15 years old, and he told me that this is the first time they ever applied this principle, this law allowing to claim, it's not backdated maintenance within an order, but claiming maintenance since the parties separated, which you are entitled to do so. It seems to me that the courts want to go forward, they do not want to investigate backwards. Let's say the child is 17 years old and the mother applies that principle. We'll have to deal with the birthing of the minor child, how much he spent on the minor child since the child's birth, all the way until now. Then we have to consider what the parties' earning capacities were for each and every year. The law allows it, it should happen. I will argue that for my client and I'll make that application to court. Because every year will be different. The court can't come with a globular amount. Because if year two the father was totally unemployed and he could not have afforded maintenance and the mother was wealthy, he should not pay. Then there might be a justification for him to pay no maintenance that specific year. But year three, so we have to work out every single year and come to an amount. But the Maintenance Act does allow it. I think it's section 16. It does allow it, and it needs to be applied. And you need to fight for your rights to obtain your maintenance.
Well, a mother tried that in the court the other day, and the maintenance court instructed her to go to small claims court or to go to civil court, and they didn't do that. She was not advised and just accepted it.
I have no idea what the maintenance court's reasons for doing that. It could be, as I mentioned early on, the cumbersomeness. It might cause a maintenance inquiry to take many, many years to be finalized because we're not going what the expense of the kids are now. We need to do a maintenance inquiry for each one of those years. And evidence could be missing, information could be missing. And what if the amount is 1 million rand and the guy can't afford it? Is it worth the energy? Felicity, I'm not giving my opinion on this issue. I'm trying to think how the maintenance courts are thinking. But they should do it. The law allows it. The law allows it.
Yeah, I know, and you know, this part of educating people is they must insist on the enforcement because it's there. You know, the thing is where it starts getting complicated is it in the best interest of the child? Well, you know, the child has survived 10 years without any support from the father, but that's not what the law is. The law says that both parents have a legal obligation from the day that the child is born. So, you know, I just keep saying that we insist on our rights and insist that they enforce the Maintenance Act, then they will just eventually just realize they have to do it because they have to. If we insist, then they will. But if we don't, then, you know, why should they do it? It's extra work. I also think that there's room in the act because it says what is fair and reasonable. So, and it also that mediation takes place. So if somebody goes to do an application and they haven't supported for 10 years, that there is the option to mediate an agreed settlement and go, okay, well, you haven't supported for 10 years. Give me a lump sum. I'll accept a lump sum of 20,000, 30,000, whatever, minimal amount. But it's the principle of getting something back that you can use to invest forward on your child. Because I mean, you've spent that money already, but it doesn't mean to say that you shouldn't be compensated for it. And is that in the best interest of the child? No, it's not. It's, you know, the best interest of the primary caregiver because they've spent that money. So it does get quite argument. It does become quite a legal argument, and it certainly would help if you had a legal person representing you. But I think that if you understand the Act and the provisions, you can still argue it as a lay person if you understand it.
Yes. Felicity, I would advise people, because of the issue, do not wait 10 years to apply for maintenance. If the party does not pay child maintenance, um, make the application immediately. If from an evidential point of view, even if the maintenance magistrate tells me, Mr. Abduroaf, we will hear the application, it will be so hard for me to prove my case because of all the possible scenarios that might arrive. Because in year 5, the parties were living together in the same home. Um, in year 6, this occurred. In year 7, that occurred. How do I, as a legal practitioner, present a claim of which is more than 10 years ago? And that's why we've got the principle of a prescription for civil matters, not the maintenance matters. The maintenance claims don't get prescribed. Is that you should sue for damages within 3 years, because if within 3 years some witnesses are alive, the mine is still working and everything. Bank statements, I'm coming back 10 years later. I mean, where do I get bank statements of 10 years? Yes, it's technically possible to go into the bank's archives and obtain those specific bank statements, but how expensive would it be? On that principle, where I'm going to with this is the lesson we can learn from this: if somebody does not pay child maintenance, approach the maintenance court immediately. Do not do so later on, because then all the type of discussions will take place. No, I gave the lady cash money every month. I gave her cash in her hand, and then she says, "You did not give cash in my hands." Then the argument will come about this. But if I didn't give a cash in your hands, why did you do nothing? Why didn't I go to the maintenance court? It can just become a evidential disaster at the end of the day. Therefore, apply as soon as possible. Maybe, Felicity, maybe we can.
Yeah, no, absolutely. Sorry, I lost you. No, I didn't hear what you said.
No, Felicity, I think maybe we can deal with the question quickly and then we can carry on, if that's fine with you.
Sure.
It's a one question. I think you'll be able to answer it. You just get to it. Where did it go? Here's it. It says the following. In a maintenance application, if the mother puts 3,000 rand for housekeeping and 1/3 of that, if you apply the 1/3 principle, she says the child's portion, the dad must contribute is 1,000 because she is contributing the other 2,000 rand per month. 1,000 from herself and 1,000 her half of the minor child. Is that right? Felicity, I do not understand that principle, because my understanding is to look at people's income and expenditure, and unless the one party does earn much more money than the other party, double the other party, then you apply the 1/3, 2/3. What's your view on that question?
Okay. So what people don't just to let's deal with that, because the next part of the application is what happens with the form is essentially you have direct expenses and you have indirect expenses. Now, the direct expenses are pretty easy. You get to a total and they get divided proportionate to income. The indirect expenses, you total indirect expenses, which are things like your rent, your electricity, your water, your shared expenses. What the applicant doesn't understand, so say for example, your shared expenses, which includes your rent, comes to 6,000 rand. Okay, the father is not liable for that 6,000 rand because that needs to be divided proportionate to incomes, because your costs are separate from that total. So that's a child's total. You're still having to contribute to the child's expenses. So that 6,000, like the direct expenses, will be divided proportionate. So in the rent, for example, if the rent is 3,000 and the child portion is 1,000, the father's contribution is a portion of that 1,000, and the primary caregiver, the mother, pays the other portion of that. There's often this misconception that applicants that the father is responsible for the child's portion in full. No, it's not. It's proportionate.
Yeah, and Felicity, it depends also. No, the law is a law. When I'm litigating these type of issues, and the one party will, if it's convenient to them, then they'll argue the 1/3, 2/3 principle. But that I never saw that principle in any case law. I do not think there is such a principle. It might be a principle of convenience, But at the end of the day is a parent is not responsible to maintaining the the parent of the child, the other parent of the child who has primary care or is claiming maintenance, his or her new spouse, his or her stepchildren, and so on.
I can't hear you. You're breaking up.
Yeah, that's fine. So can you hear me now, Felicity? Is that fine? We are going to this is there's no obligation upon the person paying the maintenance to fund the person claiming the maintenance life and his or her new spouse or stepkids and so on. The obligation is solely to maintain the minor child. Therefore, the most difficult items to work out, the most difficult amount to work out in a child maintenance matter are items like electricity, water, food, because you can't get 5 meters in a home. You can only have one electricity meter and one water meter in the house, and it's a one big amount, and you need to proportion how much each child uses. But you need to sit down with pen and paper and work it out. You need to say the water bill for the month is 100 rand, for argument's sake. The minor child, each one of us showers every day, and therefore, but however, the minor child showers maybe more or uses more water because of this and that. Therefore, based upon this household where 10 people live in, the bill is 100 rand per month. The minor child's contribution of that bill is is 10 rand. You need to sit down and work these things out. The same with the grocery bill. We have one big pot of food, there's 10 people eating, the minor child eats the same amount of food as anyone else. Therefore, his portion of the grocery bill is so much money. Therefore, allocating an amount of 100 rand for the minor child towards the groceries. That's where I'm going to. And those are the difficult ones. The easy ones are like school fees, school uniform, and medical expenditure, because you have the invoices, you have the receipts for that.
Yeah, absolutely. And then, that is quite relevant, because the question also comes up when the non-primary parent has the children for a month after holidays. The question is often asked, or they just withhold maintenance for that particular month. And the truth of the matter is that your fixed expenses are still applicable for the month. The only variant would be things like food, really, and water and electricity that might be slightly increased. So, there's this concept, well, the kids are with me, I'm not paying any maintenance this month. It's crazy, because then that just becomes arrears, and there's another court application. And so there's a lot of educating that needs to take place in this just the whole shared expenses of children.
Yeah, therefore I advise people, please, before you approach a maintenance court, or while you're busy with the process, learn the law, learn the topic, read a bit, spend a Saturday afternoon Googling and reading articles, watching videos like these, so you are well educated. When it comes to the issue regarding school holidays, it's COVID-19 now, and I'm certain a huge issue has arisen with many parents regarding the expenditure of children during this time, whereby the father had to have the kids for 2 weeks, but he had the kids now for entire month, or vice versa. On that specific point, Felicity, I would advise parents, all parents, to please be reasonable and try to discuss these issues, come to some type of agreement. But going a few steps back, when you're in a maintenance inquiry, open your mouth. I mean, we also quote in December time, the minor kids will be with me for half the school holidays. Is this amount of maintenance I'm paying to the maintenance court, does that include, or does it factor in the reality of the minor children living with me, during for half the school holidays? Either maintenance court says now, for argument's sake, yes, it does factor in, then the parties are on the same page. But if it does not factor it in, then the court has to factor it in. Therefore, you need to speak and vocalize your concerns going forward regarding a maintenance order.
Yeah, absolutely. I think that what a lot of the advice shared or experiences shared are helpful. So one of those issues are like medical aid, for example, that I see very often is very problematic, particularly if the child is on the non-primary caregiver medical aid. how problematic it is to get a copy of the card, to get pre-authorization procedures, to be reimbursed for out-of-pocket expenses. It becomes incredibly difficult when relationships are equanimous. So I advise people that where possible, if you're wanting to manage, and it really is more managing than controlling. If you want to manage your expenses properly and have full control over that management, then you need to have a child on your medical aid, because then you're in control of accessing authorization numbers and know when you have reached limits on your savings account, all of those kind of things. Otherwise, these things pop up as unexpected things. You assume that you can take the child to the doctor in March, not being aware that medical funds have been depleted already in March. And you've now incurred costs without being able to, and it becomes another argument to try and claim it back. So, there's many little things that, and these are based on relationships where the parents can't communicate and they're not understanding and want to be selfish and manipulative, and not really realizing that it's to the child's detriment. It might impact directly or initially on the parent, but it does impact on the child.
No, Felicity, that's true. Felicity, this was very exciting, very inspiring. I think at our next video next week, we can have another piece of legislation. Maybe we can deal with a maintenance application for a substitution of a maintenance order, paying more, paying less, or setting aside the maintenance order, and I'll screen the form as well. That could be for next week. But Felicity, we are running out of time. Especially when the conversation is so good, then time flies. Any final comments on your side, Felicity, before we end this video, and we're looking forward to the next one?
I'm just, that you said earlier, is I encourage people to start applications sooner rather than later. So some application, whether it's an arrears application or a variation, whatever, do ASAP, because whatever time lapses, you're out of pocket, whichever way it is, and it becomes more difficult.
Yeah, it's the same like doing your taxes. I mean, if you never done your taxes for the last 10 years, that is your documentation. How hard is it to get hold of all that type of information? So the same would be, claiming that the amount of money the other party did not contribute towards maintenance. Yes, you're entitled to do so, but there will be complications. And to avoid that, you need to do it as soon as possible. Felicity, I hope you have a wonderful day. It was nice watching you there in the breeze. I'm hot inside here, and we'll see each other online next week. And thank you very much for your time. I hope you have a wonderful weekend, and to all the viewers as well.
Thank you, Mohammed.
Felicity, are you still there? Okay, wonderful.
I am.
No, wonderful. Let me just end this video quickly.